Now let's get to the really scary part of the Fair Labor Standards Act. You do not want to violate the FLSA. I would rather pay damages from a sexual harassment suit than pay damages from a Fair Labor Standards Act violation. Here's why. If you have a violation of the FLSA and it's willful, or if the employer either knew or should have known, they go back 3 years. If it's willful. Now, if it's non-willful and it's just a mistake, they can go back 2 years. But I'll tell you, 2 years is a lot. Because think about it. Let's say that you've invalidated the salary test or somehow misclassified someone under the Fair Labor Standards Act. And they're really non-exempt, but you classified them as exempt. If it's just a mistake, you can go back 2 years. Well, you probably didn't keep a whole lot of records. So you're not going to have a whole lot to fight with. And then, just to make things more fun, under the Fair Labor Standards Act, you don't get punitive damages. Like if somebody sues you for disability discrimination or racial discrimination or something like that, you can get punitive damages. Not here. You get something called liquidated damages. Those are double damages. So in other words, we figure out what it is that you would have been paid. So we go back and we figure, okay, you were not paid overtime. You worked an average of 60 hours a week. That's 20 hours a week for 2 years times your hourly rate of $25 an hour, time and a half. So we're going to figure out that maybe you were it cost you $30,000. Okay, great, $30,000. You might have bought Microsoft. You might have bought into Bill's Pizzeria. Who knows what you would have done with the money? So we're not sure how much money you might have been able to profit from. So what we're going to do is we're just going to double it. That's a lot of damages. Well, let's look at an example of damages under the Fair Labor Standards Act. Let's look at Tom here. Well, Tom was an exempt salaried person, and he was making $800 a week in salary. Well, something went wrong. He was misclassified. He was really a non-exempt person, or through some reorganization, he basically lost all of the duties or most of the duties that gave him the classification of being exempt. Or maybe the employer did something with the salary test and invalidated Tom's exempt status. Whatever. Tom got mad. Or Tom got fired for something, like Tom was embezzling, or Tom did something and he called the Division of Wage and Hour. Now, this is an important point. Again, no one is just going to show up from the Division of Wage and Hour. They don't just show up and say, we want to look around and see what you're doing. Some employee, probably someone you fired or demoted or whatever, gets mad, calls the Division of Wage and Hour. Then they show up. Well, now they're going to look into this, and they discover that, yeah, Tom was right. You fired Tom for a legitimate reason, by the way, but you have this problem, and he was really non-exempt. So we need to calculate out what his hourly rate was, and it's pretty simple here. $800 a week divided by 40 hours a week is $20 an hour. So he averaged about 50 hours a week, and that's not that unusual for an exempt salaried person. Very believable that that person was working 50 hours a week. So that's 10 hours of overtime each week that Tom had been working for the last 2 years that he wasn't paid for. So now what we have to do, the Division of Wage and Hour has decided that Tom was right. You did misclassify him for the last 2 years. And again, we're assuming this is non-willful, which is just an honest mistake. So you take the $20 an hour that was his hourly rate, and you times that by 1.5. Why? Because that is the overtime rate, 1.5 hours. So that's $30 an hour. Now, we're going back 2 years, so we're going to deduct 2 weeks a year for vacation and whatnot. So 100 weeks for 2 years times 10 hours a week is 1,000 hours. So you're going to owe Tom $30 an hour times 1,000 hours. So that equals $30,000 that you owe Tom. Now remember, Fair Labor Standards Act does not allow for punitive damages. What's it allow for? It allows for liquidated damages. Because who knows, he might have bought AT&T stock. He might have bought Microsoft. He might have bought whatever. So his total damages to Tom, who deserved to get fired, is $60,000. That is one heck of a nice severance check. So the moral of the story, kids, don't violate the Fair Labor Standards Act. Those exemptions are critical. They can break your back. Well, let's keep our eyeball on a few other remedies that you're going to have to pay. If you violate the Fair Labor Standards Act, understand the courts, by law, by statute, are required to award, quote, quote, reasonable attorney's fees, which I promise you, when you get the judgment on this, you're not going to think they're reasonable at all. All right, so now understand, Title VII and a lot of other employment laws, awarding attorney's fees is discretionary by the judge. Not with the Fair Labor Standards Act. With the Fair Labor Standards Act, it's a requirement. The judge has no leeway here. And what are reasonable attorney's fees and costs? Well, you got to understand the whole world of employment law and labor law are specialties. So you're going to pay more for an employment attorney than you will a general practitioner. Just like in the world of medicine, you go to a general practitioner, you're not going to pay as much for your general doctor's opinion as you will an orthopedic surgeon. Difference in specialty. You're going to pay somewhere between $350 to upwards of $600-700 an hour for an employment attorney. So let me tell you right now, you do not want to be dragging this thing out because it will bite you in the form of attorney's fees and costs. Oh, and yes, by the way, one thing you should be aware of is the Fair Labor Standards Act does allow employees to sue you personally. So, yeah, you need to keep in mind that you aren't just protecting the company's assets, which is your job as a manager or supervisor or executive or something like that, but you probably like your house, right? So, yeah, if you just turn around, and these are the instances in which those types of situations come up, where you're mad at somebody and you intentionally dock them, and they're an exempt person. Or you're just purposely jerking them around. Yeah, you can get held personally liable. So you want to make sure that you are in compliance with the Fair Labor Standards Act, because I don't know about you, but I personally really like my house. Now, you have to be concerned also about retaliation and complaints under the Fair Labor Standards Act. Now, almost every law out there dealing with employment law, labor law, has a retaliation provision. I mean, it kind of makes sense. If it didn't have a retaliation provision, as soon as someone spoke up, you'd fire them. Well, that's not very good policy. That's not good form. So, here's what happened with Mr. Caston and St. Gobain Performance Plastics. Kevin Caston worked for St. Gobain, and he was complaining because the company allegedly was putting their time clocks in a location that was very inconvenient for the employees. Well, you see, this kind of makes a big difference because Mr. Caston and his coworkers would have to go clock in and then put on their equipment. That's called donning. And at the end of the day, they would take off their equipment, which is called doffing. famous donning and doffing type of thing. Well, he's saying, wait a minute, we're spending too much time doing all this stuff because you put the time clocks in a very inconvenient location. Well, St. Gobain apparently didn't like the fact that he was complaining, which later he proved to be right. The Division of Wage and Hour came in and agreed with Mr. Caston. So, what did St. Gobain do? They fired him. They fired him. Okay, so this is the stuff good lawsuits are made of. He sues under the Fair Labor Standards Act, and he's saying, I was fired in retaliation for orally complaining about the time clock situation. Now, it's important to understand that the Fair Labor Standards Act prohibits employers from retaliating against employees who have, quote, quote, filed any complaint. All right, now, what does that mean? What does it mean to, quote, quote, file a complaint? Well, Mr. Caston said, when I complained about this orally, that's filing a complaint. St. Gobain said, no, filing a complaint means you put something in writing to us. You had to put it in writing. You didn't do that. So it's not a complaint. So it's not retaliation. Kind of a real technical type of argument here that they're using. And the Seventh Circuit agreed with them. The Seventh Circuit ruled for St. Gobain, saying, yeah, the statute says that you got to put things in writing. And there's reasons for that. Evidentiary, exactly what is the complaint, those types of things. So Mr. Caston didn't like that decision. People who lose their lawsuits usually don't like those decisions. So Mr. Caston appealed and went to the United States Supreme Court. And guess what? The United States Supreme Court held for Mr. Caston. Agreed with Caston, overruled the Seventh Circuit. Basically what they're saying here is, no, we do not agree with St. Gobain that the Fair Labor Standards Act only protects written complaints. No. I mean, come on. A lot of employees are going to complain about something and they're not going to put it in writing. And it is not good policy to let an employer go out and commit corporate capital punishment on somebody who is exercising their rights. So the United States Supreme Court came back and they said, guess what? New rule here, folks. Oral complaints under the Fair Labor Standards Act count. That is a complaint. That is, quote, quote, filing a complaint. So an employee can put something in writing to you, or they can just tell you orally. Now, here's a hint to all the wise folks out there. If an employee has a complaint about anything, Fair Labor Standards Act, sexual harassment, I'm working with Bill and he's an idiot. Okay, put it in writing. Put it in writing. Actually, I've got some clients that say, look, we're going to document this. And quite frankly, it's not just documenting things in writing. We are going to have the employee give us an oral statement, and we're going to record it. Well, where do they get a recorder? Almost every personal computer out there has a recorder. Smartphones have recorders. So what do? I have a lot of clients that are training their supervisors that when someone complains about something or someone has an accident or something like this, we have them record it into a statement. And I'll tell you, there's something to that because it is very thorough when people just explain what the situation is. And understand what you're trying to do is you're trying to get a record of it. Exactly what is the complaint? Well, had Mr. Caston done that, had the supervisors required him to do that, they could have passed that recording on to human resources, on to legal, and I feel a lot more confident that the right thing would have been done.